Now to our coverage tonight of the landmark abortion ruling.
The Supreme Court issued two opinions today, all stemming from a case that originated in Mississippi, Dobbs versus Jackson. Now, the first opinion, in a 5-4 vote, directly overturned the decision made in Roe versus Wade. That was back in 1973.
And the second opinion was split 6-3. This opinion upheld a Mississippi law that bans abortions after 15 weeks, and there are very few medical exceptions to this law. Now we're taking a closer look at what could now happen at the state level. 15 states and the District of Columbia have laws in place that protect abortion now that Roe versus Wade is overturned. That's according to the Guttmacher Institute, which is a nonprofit that researches reproductive rights worldwide.
And 26 states are now certain or likely to ban abortion. Those 26 states include both Florida and Georgia. And of those states, 13 have so-called trigger laws. Those are designed to ban all or nearly all abortions, which could now go into effect.
But what exactly will happen next in Florida and Georgia?
Both states are very different with their own proposed laws about abortion. Tonight, On Your Side's Rich Johnley joins us for a closer look at each state and their own abortion laws. Rich?
Yes, thank you very much. Both Florida and Georgia have states with restrictive abortion laws, but each state has their unique laws set to take effect. The Supreme Court's ruling to overturn Roe v. Wade sent shockwaves across the country, and it will have an effect on both Georgia and Florida. According to the most recent CDC data, nearly 37,000 abortions were performed in the state of Georgia in 2019. That's fifth most in the country. Florida had the second most abortions in 2019 with nearly 72,000. Georgia already has a law that will ban abortions when a fetal heartbeat can be detected. That's at roughly 6 weeks into the pregnancy. But while the law has been passed by the House and signed by Georgia Governor Brian Kemp, it was suspended by a federal court in 2020. After today's Supreme Court ruling, the 11th Circuit Court can now overturn the federal court's ruling and thereby put Georgia's 6-week ban on abortion into law. Neither Georgia nor Florida have a trigger law to instantly ban abortions. But on July 1st, Florida's law to reduce the time a woman can get an abortion will be lowered from 24 weeks to 15 weeks. That law does not have exemptions for rape, incest, or human trafficking. John Stemberger, the president of the Florida Family Policy Council, which is a pro-life advocacy group, says that there's already pending litigation in Florida.
The pro-abortion rights movement have a lawsuit that's currently been filed in Tallahassee. They're trying to stop the law and argue that it's unconstitutional. The trial judge there in Tallahassee has been assigned the case. And as soon as there's a woman that comes forth and said, I can't get an abortion and I wanted one, she'll be a plaintiff. And then the case will start.
But with the possibility of a potential injunction, the appeals process could take months before it reaches the Florida Supreme Court. It is also entirely possible for Governors Kemp and DeSantis to call a special session in their respective state to try and pass laws that would restrict or even ban abortions altogether. In the newsroom, Rich Donnelly, First Coast News, On Your Side.
Rich, thank you so much. The majority of Americans believe that Roe versus Wade should be the law of the land. A poll from ABC News and the Washington Post shows that 54% of Americans wanted the Supreme Court to uphold the case, and 70% of people said that decisions about abortion should be left to a woman and her doctor.